Item number 1.
My Lord, by the last order, my Lord has asked the amicus curiae to have a meeting with the Chief Secretary, my Lord. We had the meeting with the Chief Secretary, my Lord, along with presence of members from Urban Affairs and CNRD Department.
Louder.
My Lord, we already had the meeting along with the presence of from the members of the CNRD Department and Urban Affairs, my Lord. So another meeting will be scheduled, my Lord, very shortly. So if my Lord can fix this matter after 2 weeks, my Lord, we can file progress report. Only one prayer, my Lord, by the last order, my Lord has recorded it only for burial ground. So it may also include the cremation ground, my Lord. Only that should be corrected.
We have said in the order that considering the scope of PIL, in the same meeting, resolution of the dispute regarding sharing of cremation ground may also be discussed and decided.
My Lord, this point has already been resolved because there is already an agreement. They are ready to share the same cremation ground, my Lord. That is already there in my report also, my Lord. So let it be for cremation ground also. Only that clarification is required, my Lord.
Yes.
Yes,
So we have referred to the cremation ground.
my Lord, here.
So what report are you talking about?
My Lord, here in this last order, my Lord, he said, considering the scope of this PIL in the same meeting, resolution of the dispute regarding sharing of cremation ground may also be discussed and decision taken. My Lord, that will suffice. My Lord, I was pointing about earlier paragraph where my Lord has stated here we direct that the immediate steps be taken by the state government to acquire the required area of land for common burial purpose, either by acquisitions or private treaty. So in place of burial ground, it can also be included cremation ground also, my Lord.
Now the question, you first resolve sharing.
My Lord. My Lord, I have already in my report, my
Because
Lord.
the space required for burial is much more
My Lord.
than for cremation. Cremation can be done in a small area,
Small area, my Lord.
provided there is cooperation.
My Lord.
If there is absolute failure in the cooperation between the two faiths or two sects, then we can think of acquisition.
Yes.
But now if we say that acquire, then they will say we all want it separately.
My Lord. My Lord, one of the report, my Lord, which I have filed, if my Lord can have a look at the report. That is report dated 8 May 2025, my lord.
What have you stated?
Here, my lord, I have stated my lord, in the report, I have stated that Senkhasi people, my lord, the Niyamkhasi people, they do not have any issue for sharing of the cremation ground with the Hindus, my lord.
Yes, please take down. The subject matter of this public interest litigation is this, full stop. Both the Hindu and no, cut out both. The Hindu, Khasi and Jaintia communities cremate their dead, full stop. But there is a division between them as regards sharing of crematoria. Full stop. The Khasi and Jaintia communities want a separate crematoria for themselves. Full stop. Paragraph. Secondly, there is acute dearth of space for burial of members of the Christian community. Full stop. This community is divided into various denominations. Full stop. Their respective churches or religious orders own cemeteries. Full stop. But a religious order usually does not permit the dead from another denomination to be buried in their cemetery. Paragraph. The need arose for a common burial ground for communities, for members of all denominations of the Christian community. Paragraph. To resolve both these issues, be appointed an amicus curiae to sit with all the stakeholders, including government and public officials, government and other public officials, and resolve the issue amicably. Paragraph. By our last order dated 7th July 2025, we directed the Chief Secretary of the State to constitute a committee comprising of a selection of stakeholders as mentioned in our order, with the hope that some kind of a settlement would be reached between the Hindus and the Khasis and Jaitiya on one hand, and members of the Christian denominations on the other hand, and also to acquire land. No, on one hand. We also directed that an acquisition of land drive may be undertaken to set up common cemeteries for members of the Christian faith or various denominations of the Christian faith. Paragraph. The amicus curiae informs us that a meeting has already been held and more meetings are likely to be held soon to resolve the above dispute. Full stop. We are told by the amicus curiae that members of the Hindu and some members of the Hindu and Khasi and Jaintia communities have agreed to share a common cremation ground. Full stop. If others can be persuaded to follow this, nothing can be better. Full stop. Otherwise, the committee might consider acquiring land for cremation purpose also. Paragraph. List is public interest litigation. On 14th August, to ascertain the position.
Obliged.
The amicus curiae which requested to file a very short report on that day.
Obliged.
Obliged.
Number 2.
Please, Mr.
Yes, please.
Well, as this matter pertains to the felling of trees, on the last occasion, a report had been filed by the state whereby they had indicated, my lords, that the tree felling in Lausatun was part of a, my lords, central government approved project. And my lords, reforestation program was going on in West Khasi Hills, my lords, and my lords have permitted me some time to examine the report and revert back to my lords. Two aspects, my lords, that have come out. Yesterday, my lords, in the Shillong Times, a report was carried, and we're carrying it, my lords, so I just wanted to place it before my lord's kind consideration. In the Goda Burman case, my lords, your lordships are aware that the Supreme Court had appointed a centrally empowered committee to oversee the, my lords, directions of reforestation or afforestation, as whatever your lordships may say. And my lords, Meghalaya appears to be at the bottom of that entire list. Well, it's Meghalaya at the bottom in compensatory afforestation program. Meghalaya recorded the lowest coverage of compensatory afforestation in India, achieving only 114.56 hectares as against the target of 514.76 hectares or 22.3%. The information was revealed in a report compiled by the Supreme Court mandated Central Empowerment Committee filed earlier this month. So, my lords, insofar as Meghalaya is concerned, even though, my lords, reports are being filed before this honorable court, that
matter is pending and that matter is being examined in Godavarman.
No, that's a different
and this
issue.
is the
What I'm
report.
trying to point out over here is, my lords, what has come in the report is that these trees have been felled in Shillong and there is reforestation or afforestation in West Khasi Hills. Now, what appears from here, my lords, is that the target is never achieved. Now, if the central government has given permission for felling of trees, my lords, I cannot really object to that. That my lords have already indicated in the last order. But it also mandates, my lords, that there should be compensatory afforestation, which doesn't seem
And
to be
in
happening.
today's newspaper, some grudge is also expressed by the minister here that because of this court order, we were unable to construct the ropeway.
No, I got it clarified, my lord. Because I saw in the Shillong Times, and your lordship has already cleared it, clarified it, and I saw in the Shillong Times, I was also surprised, my lord. How come? Because it is a approved project, so there was some confusion in his mind because sometimes they read outside the matter also, my lord. That is
After the trees have been cut.
no, that was some error.
This shows the sorry state of affairs, my lords.
My friend sought some time to file response to this report.
I said to examine the report, my lords. What has come to my notice, I've just placed it. If your lordship so, my lords, direct, I can bring this by way of an affidavit. Before
This
the court.
afforestation, this coverage is fixed by the state or center?
Everything is cleared by the central government, my lord, because the permission is granted by, and afforestation is also by pursuant to permission granted and approved by the central government.
And it is funded also by the central government.
By the
Funded
user
by
agency,
by the project proponent, by us only, my lord. because
The
we-
user agency, my lords,
User agency.
whoever will be the user agency, they
do it.
deposit the funds with the state.
So, for example, if it is the ropeway,
My
so
lords.
the tourism department will fund it.
My
Yes,
lords.
yes, that we have to do.
What is, my lords,
What Mr. Advocate General tried to do?
Yes, my lord.
You try to do it in a surrounding a neighboring area.
That is most desirable, my lord. That is most desirable because at times, my lord, your lordship has seen we face difficulty in getting land because most of the lands are not
Well, it's as a
owned
matter
by
of
the
fact.
government. These lands are owned by the private entities and individuals, my lord. Wherever we
this
get
land
land,
is the land where the afforestation is going on is also a private land, my lords, which
but
was
we
acquired.
because wherever we get the land, because if we can't get the land in the middle of the city, and so wherever we get land, we acquire and pay, and we do the afforestation, my lord. A desirable and most ideal situation is that we should do it in the vicinity only, my lord.
As a matter of fact, this honorable court, my lords, a coordinate bench of this honorable court, in another
one of the
PIL,
matter, my lord, has
another
already-
PIL filed by me, my lords, whereas the petition in person, has directed that in the same vicinity, the same number of trees should be planted, my lords, of the same species. That order, my lords, I crave your lordship's indulgence to bring it on record.
So provided a report is first obtained
My
Yes,
lords,
my lord.
regarding the availability of land,
Yes,
my lords.
and if it is not available, how to make it available, to make this kind of an objective fruitful.
Yes, my lord.
And if not, Malaj, in the immediate vicinity, it should be at least in
Otherwise,
the same district.
the order will remain non-complied with.
Yes, my lord. Your lordship is right. Absolutely right. Because otherwise it will be on papers only if the land is not available. So my friend has to file a response to this report, my lord. And once he files and he has any issues, we will try to address those issues. We have no, because it's not an adversarial proceeding, my lord. We are on the same page.
I am only saying, Malaj, that on paper there is afforestation in some other district, Malaj, in one distant corner of the state. As it appears, Malaj, the afforestation program is also not going as it should. There are states which have achieved 100% and in thousands of hectares. Madhya Pradesh, Malaj, in this very report says it has achieved, Malaj, 21,746 hectares of afforestation. Arunachal, Malaj, has achieved 21,473 hectares. Here, Malaj, instead of 514, we've been able to achieve only 114. That's 22%. We're the lowest in the country.
Because we have not seen the report. What my friend is reading from Ceylon Times, and my friend, Ceylon Times, every day we get some news against us only and without any. Let the report be there because, and we'll go through and we'll respond to it, my lord. We'll respond
And
to
also
it.
you file a report
Yes, my lord.
after making due inspection of the area.
Yes, my lord.
To what
We'll do that.
extent
We'll do that.
afforestation
Yes, my lord.
to replace and replenish whatever has been
Yes, my lord.
removed from there,
yes, please.
it can be carried out
Yes, my lord.
to
In
restore the ecological balance.
And if my friend can accompany me, or
Malaj,
we can,
I was just thinking
we
that
will be.
if your lordship so permit, Malaj, that Malaj, we can, Malaj, my learned friend, the Advocate General, as well as myself, Malaj, we can go and cause a spot inspection and file a report before this Honorable Court on both these issues.
Would you have the time, Mr. Paul?
Most difficult.
and so with the Advocate General.
It will be a welcome break for both of us. Malaj. Going to West Khasi Hills and coming back, Malaj, may be a welcome break for both.
What is the distance?
About 2 hours.
3 hours. It will take about 3 hours.
And more than 100.
It'll be about 100 kilometers. More than. But Malaj, we would be in a better position to apprise this Honorable Court as to what is the actual ground situation. Because as it appears, Malaj, it's...
But this is relating to afforestation aspect of the matter.
Which is what I'm saying, Malaj. Because what happens is, when the trees are required to be cut in and around, Malaj, they are done with hottest haste. Overnight, Malaj, forest was reduced to, Malaj, a barren land, and that is the report. And there is compensatory afforestation happening elsewhere, Malaj, but these projects unfortunately never seem to have taken off.
Yes, please take down. This public interest litigation complained of alleged indiscriminate and large scale inter alia, indiscriminate and large scale felling of trees in the Losotun area of East Khasi Hills district. Paragraph. On receipt of a proper report from the concerned authorities, it transpired that this deforestation was carried out, after obtaining due permission from the central government under the relevant act and rules for the construction of the Shillong Peak Ropeway Cable Car Project. at Laban Reserve Forest and RAID Laban Forest by the Tourism Department of the state government. Paragraph, Mr. Paul Leonard, Senior Advocate, appearing for the petitioner, shows us a newspaper report
That's urgent.
and argues that on such deforestation being done, the state government was enjoined with a duty to do afforestation. To do compensatory afforestation. Full stop. According to this newspaper report, their afforestation achievement is the lowest in the country. Full stop. This afforestation, compensatory afforestation, includes other areas also. Paragraph. Now, the main submission on behalf of the petitioner is that when the central government has authorized deforestation for the ropeway cable car project, and such deforestation has been carried out, and such activity has been carried out, there should be proper compensatory afforestation in the vicinity of the project to make up any loss of ecological balance.
Connect to the Wi-Fi, no?
Or environmental ecological balance or loss in environmental attributes. Full stop. Learned Advocate General says that his government is prepared to carry out afforestation, but problems arise with regard to availability of land in the subject area. Paragraph. At the suggestion of learned counsel for the parties, we request the learned Advocate General and Mr. Paul to identify a convenient day, visit the area and file a short report in this court regarding the prospect of carrying out afforestation work around the ropeway cable car project area. The state government is directed to make all arrangements for their travel and for their brief stay in a suitable government guest house or accommodation near the area, in or near the area. Paragraph. The petitioner may also file a rejoinder to the report filed by the state government today before the returnable date. We make this PIL returnable on 14th August.
14th of August. I'll be back.
Number 3.
Looks, here is an application under Section 5 of the Limitation Act for condonation of delay. My lords have directed issuance of notice. My lords, we've served notice and filed an affidavit of service.
Yes. Condonation of delay in a review application.
My lords.
What is the delay?
My lords, it is 8,315 days.
8,000.
My lords.
May it please your lordship. Your lordship, I'm entering appearance on behalf of the respondent number 5, your lordship.
And for the other respondents?
Your lordship, the respondent number 4 had expired, your lordship.
I'm for 1, 2 and 3, your lordship.
Sorry?
I'm for 1, 2 and 3. Respondent 1, 2 and 3, your lordship.
Respondent number 1 to 4.
1, 2 and 3, your lordship.
And 4?
4 had expired, your lordship. I am appearing on behalf of the respondent number 5, your lordship. She is the wife of the respondent number 4, your lordship.
To file affidavits?
Your lordship, if I may, your lordship, I would like to submit, your lordship.
You file an affidavit.
Lordship.
This application for review is accompanied by an application for condonation of delay of over 8,000 days. Let affidavits be next. Let affidavits be exchanged according to the following direction: colon, affidavit in opposition by 11th August. Rejoinder affidavit by 20th, list the review petition along with the application for condonation of delay on 21st August.
I'll be obliged.
Number 4 and 5.
Wait, please, George.
Number 4 and 5, I'm waiting for the petitioners. My lord, on the last occasion, this matter was adjourned on the ground of the settlement talks which was going on, my lord.
Yes.
We have submitted our proposal on 9th of June. 2 meetings have already been held as of now. But as per the last minutes of the meeting, which was circulated to us only yesterday, we find that the state requires some more additional time because they are assessing the claims.
Because certain documents have been furnished in support of the claims, about 4 annexes. So therefore, it will take some time, my lord.
My lord, just adjourn the matter for 3 weeks. 3 weeks.
It may adjourn the matter of 3.
And we'll be pleased to extend the interim orders which was granted on the last.
We have said subsisting
Yes, interim order is still disposal of appeal.
My lord, or till the further orders, whichever is earlier, my lord.
No, this is last order says
That
till
has
the
to be
disposal
there.
of the appeal.
And the line after that. Or until further orders, whichever is earlier. So that means it's today, sir.
That is always there.
They have all this.
My lord, will kindly extend. We will put the paragraph in today's order also.
It's there. It stays
The
there.
extension will benefit you.
No,
If it does, we will.
My lord, it will definitely. Otherwise,
All right. Same as the order dated 30th June. All right, we're dictating a fresh order. On the joint prayer of learned appearing counsel, the appeal and the connected applications are adjourned till how long?
3 weeks, my lord. 3 weeks.
20th August.
Grateful, my lord.
Comma, as it is submitted that the settlement process is satisfactorily continuing. Paragraph. We reiterate that all interim orders which are operating shall continue till the disposal of the appeal and the connected applications or until further orders, whichever is earlier.
much obliged.
Number 6.
Your Lordship has heard my learned friend at length on the last day.
Not yet completed. I have not yet completed here. Lordship, on the last occasion, that is on 27th of June last, I have already submitted the synopsis of my written argument, serving copy to my learned friend also. Now, today, I only make an attempt to summarize this, my synopsis to another gist of my synopsis. Lordship, in the present appeal, it is to be considered whether the money suit was filed within time or not. That is the main issue. And according to Article 55 under Section and read with Section 3 of the Limitation Act, this any suit, when any cause of action arises, it is to be filed within 3 years. Now, 3 years, here in this particular case, Your Lordship, It's a contractual matter that immediately after the termination of the contract, the FCI could not have assailed or filed any money suit. Some contractual obligations are there. Notices are to be issued as per the agreement that they are to the work will be done by appointing ad hoc contractor and with the at the risk and cost of the failed contractor. And in such circumstances, what happened, Lordship? The first demand notice was sent to the respondent, deceased contractor, Dranley Lindo. And upon receipt of that, he at once went to civil court, Lordship, and filed a civil suit by title suit number 26 T of 2011 with a further interim injunction petition by Miss Case number 63 of 2011. And that has been renumbered, Lordship. What happened at that juncture? They started the process in Meghalaya, the separation of executive having concurrent judicial power with judicial force. So that process started, a lengthy process. It took some time, Lordship. So what happened? The trial court on the 22nd of August, when the case was filed, at the initial stage, ex parte granted status quo, and we have been served the notice asking us to give in 7 days' time, you file your show cause, whether injunction should be considered or not. We filed our show cause, and as I just submitted that the process of separation started, all cases were kept in abeyance. So it took about a few months, Lordship, to conclude the process, and thereafter, after the transfer of all these cases from the executive side, all are renumbered. Your Lordship will notice that the TS2 26T 2011 was renumbered after shipment transferring to the 2013 212T of 2013. In short, Your Honor, it took time, and we filed our show cause, and this after the courts started process, regular process of hearing started. Then we made our hearing. Some was taken, part is taken, some due to some reasons, Your Honor, the matter was dragged, and the injunction petition by which they sought restrainment over the notice of demand we wanted has been rejected because no prima facie case as per the contractual agreement could be placed before the court. So what happened, Lordship? As there is no doubt, this is admitted fact, this cause of action had arisen on 18th of January 2011. And after that, Your Lordship, this process I have just explained to Your Lordship, and then came the civil court's direction by final is 29/8/2011 that status quo would continue. Now, in that way, that status quo gone automatically vacated when the injunction petition was rejected by order dated 7/3/2018, Lordship. Now, my humble submission that when this 3 years period was to be completed by 17/1 of 2014, Lordship. So on this 2017 January 2014, we are under restrainment of status quo order. So we could not take any step in that regard. In that way, the limitation which was running was arrested by the Honorable Trial Court's order, Civil Court's order. Now the next second phase of our 3 years limitation had started from 7/3/2018, Lordship. Because 7/3/2018 was the date of order by which the trial court has vacated set aside or rejected the injunction petition and the status quo order vacated. Now it has started from 7/3/2018 on. So second spell of 3 years limitation that has started afresh from 7/3/2021 was again it was to be concluded by your 3 years, means 8/3/2000. It 7/3 to it will ended by 7/3/2021, Lordship. So in the 21 already this COVID started, Lordship. But the COVID already started, so nothing could be done regarding this COVID pandemic matter. I feel, Lordship, we are not to go further. Then in such circumstances, what happened, Lordship? The Honorable Supreme Court, suo motu, by its order dated 10/1/2022, has directed all the courts, tribunals, including high courts, that the period from 15/3/2022 up to 28/2/2022, that is about 716 days, will be given exempted period, Lordship. Now again it is made in further direction that in such circumstances the courts, tribunals, and court below, all authorities below, legal authorities, they are to assess the period of limitation for the remaining period of limitation on 3/7/2021. The reason being that, Lordship, this order in the Supreme Court was passed in 2 phases. First phase when this COVID was a bit receded, then this position was 3/10/2021. Again it has mounted. So the order dated 10/1/2022 was required to be passed finally, Lordship. So now what happened, Lordship? In this exemption matter or excluded matter, the Honorable Supreme Court again stated that whatever balanced period of limitation will be available on 3/10/2021, it can be used after with 1/3/2022. But there is further one direction that if any person or in any case, when on 3/10/2021 there is no balanced period of limitation, then in such circumstances, such person will get 90 days further with effect from 1/3/2022. That is the question, Lordship. Now, had there been, Your Lordship, I beg to submit, had there been no COVID taking that, then we should have filed the case by 7/3/2021. But we could not file it. But we have filed it on 21/3/2023 after a lapse of 2 years, 14 days. But if the excluded period of 2 years, 2 months, and 16 days means, Lordship, first relaxation.
When did your cause of action arise?
Lordship?
When did your cause of action arise?
My first cause of action arose on 18/1/2011. Then it had ended, Lordship, 17/1/2014. Second phase started from 7/3/2018 because 7/3/83 the injunction, status quo order was vacated. We got the scope to file it. But what happened? That again the new spell started, which had just ended in midst of the exempted or excluded period. So totally as per the Honorable Supreme Court's direction, we got the benefit of...
No, where it started.
Started means initially started.
It is only once. It doesn't. Rarely it is in stages. Cause of action, once it starts, right to sue also accrues, and then it continues.
Yes, means when the, as per section 3, there is that when the limitation starts running, if by any judicial process it is not arrested,
When it
will
started,
continue, Your Lordship.
when it started running.
It first started from 18/1/2011.
Yes. Why are you saying first? What happened at that time?
At that time, what happened? We were to take our obligations under the contract, and we issued notice to them that we have already appointed a contractor, and the corporation has lost about 67 lakhs. You pay that amount. So when he received that notice of 67 lakhs, then at once he came to the court and filed a civil suit, praying that a declaration that the plaintiff as a contractor is not required to pay this amount, and also file an ad interim injunction petition to stay the process of the notice. The learned trial court, what happened on the very day of ex parte motion, granted status quo. And within 1 week, we have been given the chance, we appeared. And we sought for little time because this is a contractual matter. So, trial court made an order on 29/8 that this status quo would continue. We filed our show cause, but that entire hearing, etc., was delayed for separation of judiciary from executive. And all this then, ultimately, after 6 years, this miscellaneous petition on the stay order was vacated by 7/3/2018, Lordship.
And
so we had checked.
And your suit was filed?
We filed our suit on 21/3/2023. Because at that time, when our second spell of limitation started, COVID entered, Lordship. So, but COVID has taken about 2 years' time.
How are you calculating a fresh period of 3 years?
Yes, Lordship.
Let us assume that up to 2018 exclusion.
Yes, Lordship.
Now from 2018, how are you taking 3 years?
Yes, 2018, Lordship, what happened? My last
Please listen
spell
to
of
us.
3 years.
Your cause of action 2011.
Yes.
Your suit is 2014. Right?
Pardon?
The suit was 2014.
No, my suit was...
The injunction was from 2014.
No, injunction was 2011, see. Not 14, Lordship. Injunction was, we have been injuncted, restrained, by order dated 22/8/2011, and further on 29/8/2011, it was continued, allowed to continue. We filed our show cause, we wanted that it should be vacated, but matter was dragged. Interception was that separation of judiciary from executive started, and so therefore about 2 years of time consumed roughly, that all the records are transferred to the judicial side. It was renumbered, re-registered, then again process of hearing started, and it took ultimately about 6 years to vacate this status quo order, Lordship. So it was vacated on 7/3/2018. And our limitation for the first spell was arrested and exhausted during this course of hearing. Status quo order. So when we got this second spell, again what happened? COVID entered. The basic question which was I like to hinge upon here, Lordship, that in the matter of any case under section 3, that the spell of 3 years, a party is at liberty to file within that 3 years period for which no other no question can arise except if such a situation court or wants to explanation. I have explained, Your Lordship, that we are not in any way delayed the matter intentionally. These are the external causes came and restrained us. We could not do it. So in short, I like to place before Your Lordship that I'm just placing, had there been no COVID-19 pandemic, the FCI as plaintiff before this trial court should have filed the suit within 7/3/2021, but they filed it on 21st/3/2023 after a lapse of 2 years, 14 days. But if the excluded period of 2 years, 2 months, 16 days means 716 days plus 90 days, total 816 days. If they are calculated, it becomes, Your Lordship, should have been filed after 2 months, 2 days, Lordship. Because our delay and the rescue we got for the 2 years, 2 months, 16 days. So we are rather in the form of credit.
No, injunction was lifted when? 2018?
Yes, Lordship.
Which month and date?
This is on 7/3/2018.
So even if we give you, you are taking how many days from that time?
Lordship, 7/3, my question is here that it is not a matter to be considered under Section 5 of the Limitation Act. Here it is, the basic differences, it is under Section 3. There is a spell of 3 years. A party intending to file a suit can file within this period of 3 years. There is no question arises to seek any objection from any corner that you have not filed. We have to explain this or that. My spell is 3 years. At any moment within 3 years, I may come.
3 years,
if I do not come,
3 years from 2011.
Yes, when the second spell of
First
limitation
spell
started
will-
from 8/3/2018.
Those are exclusionary periods.
Yes.
Lordship?
Those are exclusionary periods.
Yes. My second spell has exhausted during the period 15 February 2020 to
Did you
28
terminate the contract?
2022, Lordship.
Did you terminate the contract? Did you?
We have terminated the contract on 18th of January 2011, Lordship. Because ours is a department, it is a mandate to maintain the food regularity chain, Lordship. We cannot wait for, we went to the state government.
When he filed the suit?
Lordship?
When he filed the suit?
He filed the suit in 2011.
When?
22/8, Your Lordship.
22nd August.
18/1/2011, the termination of the contract was there. The status quo order is of 22/8/2011, my lord.
Yes.
So there is a 7 months where my learned friend is not adding. That's what is causing all the problems.
Yeah, the question, my lord, my period is 3 years. At any moment I can come within 3 years. No, because my learned friend is considering my case is under Section 5 of the Limitation Act. It is under Section 3. My spell is 3 years.
My lord,
Within 3 years, at any time I can assail my grievance before the trial court, appropriate court.
You see, you have to, we will continue again tomorrow.
Pardon?
We will continue tomorrow. Your cause of action and right to sue.
Yes.
Right to sue, Lordship.
Accrued on 18 January
18 January 2011. Lordship.
Suit actually filed when?
Suit we filed on 21st/3/2023.
All right.
Because of this impediments,
Please allow,
court's order.
please allow the court to say
Yes, Lordship.
something.
Yes, Lordship.
From 18 January 2011
Yes, Lordship.
to the date of filing,
Date of filing.
All right. Please ask your junior to calculate the number of years and months. From there, what will be deducted is the number of days during which the injunction operated.
Your Lordship has earlier directed me. I have given that computation at page 52. Your Lordship will just give me.
Injunction operated.
Yes.
And if upon operation of the injunction, you had still time to file the suit, I think 15th March is the date
Yes,
of the
Lordship.
Supreme Court.
Lordship.
So 2020.
Yes, Lordship.
If you still had time to file the suit on 15 March 2020, then by virtue of Supreme Court orders, that period is accordingly extended. Please make a kind of a mathematical note. If not already made, we will hear again tomorrow.
My Lord, your Lordship will kindly give me 2 minutes so my learned friend can go back today and reflect, my Lord. My Lord, this termination of the contract, your Lordship will kindly note, was 18/1/2011. Correct? My Lord, then the status quo order is of 22/8/2011. That is after 7 months. If 7 months is done, it is, I have calculated date, it is 200 and...
Not in that way, learned counsel.
Yes.
You have to take 18 January 2011
Yes.
and the actual date of filing of the suit.
Actual, yes. Then we have
And deduct from that the exclusionary periods. And if it comes to within 3 years, it is okay. If it does not come, does not come. With the rider that the period ought to have been alive on the date of operation of the Supreme Court order. Or Supreme Court was from which date?
Supreme Court order was of 15 March 2020. So what did the Supreme Court say, my Lord? That suppose that during that COVID period, if the limitation period expires, suppose it is less than 90 days, then any person will have the 90 days limitation period. Suppose it is more than 90 days, then the actual period, in this case, the more period was 4 months and odd days. So it is more than 90 days. He will not only get 90 days, he will get 4 months and odd days. Why this calculation has gone wrong so far my learned friend is concerned? Because he have not excluded the days of 7 months from the date of the filing till the status quo. That's why he wants to...
You will get it if you make the calculation in that way.
We have already done at page 52. We'll simplify it further, my Lord.
Mr. Chaudhary, we will hear you
Lordship,
again tomorrow.
I shall do it as your Lordship directed. On the next day, we'll place it. But kindly consider my humble submission that my case is under Section 3 of the Limitation Act.
Yes.
My spell is 3 years. I can fight the case within any time within 3 years. Here, the question of Section 5 limitation is not coming.
No, even we
My
are not...
friend is calculating, trying to lead the Honorable Court to Section 5 limitation.
No, we are running a little short of time, but please read Section 15.
Yes, my Lord.
15, subsection 1.
Yes, my Lord.
Section 15, Lordship.
Yes.
And for Section 16, my Lord, the total period will be excluded is 6 years, 6 months and 16 days.
The period of limitation of any suit or application for the execution of a decree, the institution or execution of which has been stayed by injunction or order, the time of the continuance of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded.
And
You don't get a fresh term of 3 years.
yes, my Lord.
That you get if there is an admission in writing.
Yes, my Lord.
In section 18, 19, etc.
Yes, my Lord. Your Lordship is absolutely right. So far, this injunction period was concerned, it was 6 years, 6 months and 16 days. We say that you will get this benefit, but you have to count it from day one. That 7 months you have to include. My learned friend calculation doesn't include
I have
that.
the explanation, Lordship. I will give it, if need be, one affidavit of facts. Because the relation between the two parties is a contractual one. Now, in the contractual world, first we exercised our power under clause 10B. It says that without terminating your contract, we are appointing ad hoc contractor, and you will have to bear the differential cost the corporation will incur. Now, that is a system according to our MTF, that the contractor will feel it to be it is an alarming sound. So,
Mr. Chaudhary, you will do the matter tomorrow.
Lordship, tomorrow,
Let there be some continuity.
We have already done the competition at page 52. My
All
learned
right.
friend has to verify.
Please understand there is some paucity of time today. We will finish it tomorrow.
Hallelujah, sir, I'm here. This time I came for 2
all
days.
right, Lordship, I am
had-
ready to.
All right, please. Mr. Chaudhary proceeds with his argument but does not conclude the same. Lists this appeal for further argument tomorrow.
Much appreciated.
Bracket 31st.
You need not pray. It will be on the top of the list, I suppose.
Yes. But then I do not know whether you are aware, there is some good news of swearing in of as a permanent judge of our brother Bhattacharya tomorrow.
So we'll be part of that celebration. madam.
Yes. So in any case, the
After that,
Yes.
after that the court will sit.
Yes, madam.
much.
Well, swearing in will be at 10, I suppose, madam.
Yes.
Swearing in is, I suppose, at 10.
10:15.
10.
Number 7.
God bless you.
It is subject to the approval of the governor, of the honorable governor.
We'll
The
check
pap-
in the
yes,
website of the court.
yes, the papers have gone to him for seeking his approval.
Today we had 4 judges in the Guwahati High Court.
Yes. So we hope it will be tomorrow at 10:15.
Yes, we'll be there.
May I please, Your Lordship? Conducting counsel is out of station, Lordship. Let matter come after 2 weeks, Lordship.
Sorry?
After 2 weeks, Lordship.
After?
2 weeks, Lordship.
Why 2 weeks at a time?
Conducting counsel is out of station, Lordship.
Yes?
No objection, Your Lordship.
Good. By consent of learned counsel for the parties, this appeal is adjourned till 20th August.
I do bless Lordship.
Obliged, Your Lordship.
But I tend to my apology, my lord. Last week I had some medical issues, my lord. I could not.
Today you are all right?
Today also I'm not so well, my lord. Mr. Paul is supposed to reply today, my lord. If Mr. Paul can continue, then I'll reply. I'll pray for some accommodation, my lord, today.
So this matter has to be finished, no?
My lord. I appreciate, my lord. Only because of medical issues, my lord. I had a slip disc issues, my lord. I could not.
You're all right now?
Slightly better, my lord, now.
On the joint prayer of learned counsel, on the joint prayer of appearing learned counsel, this application is adjourned till 8th August.
8th August, my lord. I think by then I'll be able to. My lord.
Yes. Comma with the expectation that hearing would be expedited and concluded as early as possible.
Well,
8th August, Mr. Paul.
I'm so obliged.
And try to complete it
my lord.
more or less on a day-by-day basis. We should complete it.
Well,